In civil procedure, service of process, which initiates a suit, gives a court personal jurisdiction to exercise its authority over a party. There are four basic ways to serve a party with process. First, by personally serving a party in the state where suit is being filed. Second, by serving a party domiciled in the state where suit is being filed, but who's temporarily outside the state. Third, by serving a party who's not a resident of the state where suit is being filed, but who has sufficient contacts with the state. And fourth, by serving an agent who has been appointed, either expressly or by law, to handle service of process for another. In the 1956 case, Tickle v. Barton, the West Virginia Supreme Court of Appeals considered whether personally serving process in a state is valid if the person being served is induced into coming into the state by fraud or trickery. Richard Tickle was an infant who lived in West Virginia. Additionally, Raymond Barton and Lawrence Coleman were residents of Virginia. Around 1955, Coleman was driving Barton's vehicle in West Virginia. While driving, Lawrence drove onto private property and struck Tickle, causing Tickle to suffer injuries. Following the accident, Coleman and Barton returned to Virginia. Tickle, through his next friend, or legal representative, then sought to serve Barton with process by having a sheriff personally serve him while he was in West Virginia. But to get Barton to return to West Virginia, Tickle's attorney came up with a plan. Tickle's attorney called Barton at his home in Virginia and told him that he was calling on behalf of the sponsors of a banquet honoring War High School's championship football team. Further, the attorney told Barton that the banquet was being held at War Junior High School on December 6, and he was extending an invite to Barton, whose son had been a member of the team. And although Barton asked the attorney for his name, the attorney didn't disclose his identity. However, when Barton arrived, no banquet was being held, and Barton was instead served with process. Subsequently, Barton made a special appearance in State Circuit Court to challenge the validity of the service of process on the ground that he had been induced to come to West Virginia by fraud and trickery. In response, Tickle filed a demurrer, or objection to the challenge, which the court overruled. The court then certified its ruling to the West Virginia Supreme Court of Appeals.